The fact that you've been fired doesn't necessarily mean, even if the reason is false, doesn't necessarily mean you've been wrongfully terminated in the legal sense. For instance, the employer thinks you're doing something incorrect, receives complaints from clients, and decides to fire you, and your response is, but I didn't do that. That is not necessarily a wrongful termination if the employer can defend its reasons independent of you. In other words, if the employer can say, look, we had complaints about you, they may not be true, but that's not necessarily a wrongful termination. A wrongful termination occurs when an employer generally takes into account some factor that should have nothing to do with your ability to be an employee. The law says they can't take into account your race, your sex, your age, your disability status, your service in the United States military, and in certain instances, other activities such as jury duty and voting and things like that, that the employer cannot take that into account in an employment decision. In those instances, an attorney can help you decide, in looking at those facts, whether in fact, from a legal point of view, you have been actually discharged or terminated in a way that allows you a remedy. Many discharges and terminations are wrongful, and many clients come in to me and say, I've been fired and it's wrong, and I often agree with them. But the law only allows certain remedies, and so coming in and saying you've been wrongfully terminated doesn't end the issue, it starts it. And that's why you need an attorney to help you figure out whether or not the reason for which you've been terminated is something that you can get a remedy for.